my lords, I just want to spend a few moments then on each of the features, elements of the facts, facts which are relevant, which will be relevant and inform the court's consideration in relation to each of grounds 2, 3, and 4. First, and I can deal with the first ones fairly swiftly. The Bank of Uganda, as the central Bank of Uganda, I don't think it's necessary to turn it up. I can just give you the references. Part of Chapter 9 of the Constitution, which is at Supplemental Bundle 1, Tab 9, deals with the Central Bank of Uganda. Article 161 of the Constitution provides that the Bank of Uganda is the central bank of the state, and Article 162 on bundle page 137 deals with the functions of the bank, which include promotion of economic development through effective and efficient operation of a banking and credit system. Article 189.1 on page 140, together with the 6th schedule, paragraph 3 on page 141, establishes that these are governmental functions, functions for which the government is responsible through the central bank. The judge found in paragraph 22 and following that the Bank of Uganda is relevantly a part of the executive of the Ugandan state for the purposes of considering the Act of State rule. The appellants had argued below that it was not. That finding is not challenged.
Well, it's an emanation of the Ugandan state, effectively.
Indeed so, and but importantly with those functions. Then in relation to, then turning to the second point, the second feature, which is to look at the powers, the regulatory powers, which are the subject of specific allegations in the amended particulars of claim. The relevant powers are those provided in the Financial Institutions Act 2004, which is at the next tab, so the Supplemental Bundle 1, tab 10. And if I may take this a little slower just to show you the relevant parts. This, again, relevant both to the Sovereign Act question and Kirkpatrick. You will see at the top of page 148 in the long title that the Act is to revise and consolidate the law related to financial institutions to provide for the regulation, control and discipline of financial institutions by the central bank. Section 26 Sections 26 and 27 on page 160 deal with the minimum capital requirements and are prescribed there. The falling below those capital requirements triggers powers under section 86, which is on page 167. Section 86.1, an undercapitalized financial institution is one which does not comply fully with any or all of the capital requirements prescribed in sections 26 and 27 of this Act. 2, where a financial institution is undercapitalized, the central bank shall take the following actions against that financial institution, and then the actions it can take are there set out. Non-compliance with orders made against a financial institution in relation to being undercapitalized can then lead to intervention, which includes the appointment, or can include the appointment of a statutory manager. That's section 82 on page 165. And then at sections 87 and 88 and following deal with the central bank's powers of taking over management, appointment of a statutory manager and so on, including the obligation, you will note, under section 87 3 if at any time after the period specified, the financial institution fails to raise its capital to the levels necessary to rectify its significant undercapitalization or its financial position continues to deteriorate, the central bank shall, without having to wait for the expiry of that period, close the financial institution and place it under receivership, or where the closure of the financial institution would pose a systemic risk to the stability of the financial system, the central bank shall take the financial institution into statutory management in accordance with section 88. The statutory manager's powers include powers which are very particular to the central bank's supervision and regulatory objects. So, for example, section 90, which deals with the duties of a statutory manager, section 90 sub 5 on page 172, for the purposes of discharging his or her functions under this section, the statutory manager may declare a moratorium on the payment by the institution of its liabilities to depositors and other creditors. As Milan Friend told you yesterday, a critical part of the claimants case is that the BOU took CBL out of statutory management and put it into receivership so that it could sell assets and liabilities of CBL to DFCU. At the bottom of page 173, going over to 174, is section 94, which gives the BOU power to do that. And section 95 is important because it shows that this kind of receivership is not at all like a private law receiver, not like an LPA receiver, where the receiver is only concerned to obtain maximum value for the benefit of creditors. Section 95(1), the central bank shall within 12 months from the date of taking over as a receiver consider and implement any or all of the following options, either singly or in combination: arrange a merger, arrange for the purchase of assets and assumption of all or some of the liabilities by other financial institutions, arrange to sell the financial institution, liquidate the assets of the financial institution. And then the central bank shall take the action described in subsection 1, which in the opinion of the central bank, A, is most likely to result in marshalling the greatest amount of the financial institution's assets, or protects the interests of depositors, or minimizes costs to the deposit protection fund, or ensures stability of the financial sector. What one sees from that is that the considerations that the central bank must take into account in deciding what to do, having taken the financial institution into receivership, will include considerations that go to its financial sector regulatory and supervisory powers, and might well be matters that go against the interests of shareholders or creditors. That is important to bear in mind, both in relation to ground 2 and ground 4. For ground 2, it's important because it shows that the taking of CBL into receivership and the sale of assets and liabilities under these powers was in furtherance of the exercise of sovereign powers of regulation and bank resolution. And for ground 4, Kirkpatrick, it's important because the claimants rely on section 95(2) and allege breach by the Bank of Uganda of section 95(2), both in taking CBL into receivership and then selling assets and liabilities pursuant to it. I'll give you the reference in the pleading, I'll come back to it a little later, but it's paragraphs 39, 40, 41 and 45 of the amended particulars of claim. That allegation of breach is pleaded as having occurred after the defendants are alleged to have, in the words of the pleading, joined the corrupt scheme. So this is an essential part of the unlawful means which they rely on. In other words, a court trying the claim would have to determine whether the Bank of Uganda had acted unlawfully in that regard, in breach of section 95, both as to the taking of CBL into receivership and as to sale. And I'll come back to that specifically in the context of
section 95 isn't relevant to the decision to take over, to appoint itself as a receiver, is it?
no, as to what to do once.
Well, as I understand it, 95(2) are the factors that the central bank is supposed to take into account in deciding which of A to D to undertake. Once it is decided to sell the financial institution, or liquidate the assets in this case, that then, it seems to me, is a simple private law action, since it's the actual sale of the assets.
No, I don't accept that. In fact, just in terms of where your lordship started, the P&A agreement would probably more naturally fit as a 95(1)(b) in terms of options. Arranging for the purchase of assets and assumption, but that doesn't matter. But no, my lord, I don't accept that. I don't accept that the characterization of the nature of the entry, the BOU's entry into the P&A agreement can ignore the fact that that is being done and by the central bank having placed it into receivership.
Why not?
So the section. For a number of reasons which I'll come to, but perhaps most centrally because the test to apply as per Lord Wilberforce in the Playa Larga is that the nature of the act must be considered in its context. And its context must, in my submission, include the taking into consideration from the central bank perspective of the powers and the source of its powers. This is not, as I'll develop, this is not a point about purpose, it's not a point about motive. There's no disagreement between us as to what the law is, but the correct consideration of the context requires what has happened before to be taken into consideration, and I'll address also the reason why the Kuwait Airways case is not
Once it's gone through the process under the statutes, and it has appointed itself receiver, and then it's gone through the process under 95(2) of deciding what to do, and it has decided to arrange for the purchase of assets that point, why is it in any different position to any other receiver who is selling the company's assets?
Because the reason the central bank is entering into the P&A agreement pursuant to powers of bank resolution, and in furtherance of the previous steps in relation to considering its duties in relation to regulation and bringing the financial institution.
Well, it's like a government that's going to war, so it buys boots.
No, not at all. Not at all. No, it's the context. First point is that
The question for the court is the nature of the act of
Yes.
sale at this point.
no.
Yes, the point my lord's putting to you is that the nature of the act of sale is such that it's something that any other receiver could have done.
No, I don't accept that that's the correct formulation of the question. It's not the nature of the act of sale. It is the nature of the act of state. And the act of state is the state entity entering into that agreement. And it enters into it as receiver, not as my own friend suggested, on behalf of CBL. And I'm not sure on what basis he suggested that. It's not on behalf of CBL. This is a receivership under Section 94, in furtherance of and in exercise of the same powers and with the same objects as all the previous steps.
But does that depend on which of two A, B, C or D are engaged? Because A is what a private law receiver would be obliged to do. I quite understand you say if what the bank was doing was purporting to rely on D and ensure stability of the financial sector, then that might be a sale which was of an entirely different character to what a private receiver might do. But, are we concerned in this case with something that purports to be exercise of powers under 2A, essentially getting in the assets?
Well, I mean, the answer in terms of what we're concerned with is what's alleged in the pleading. What's alleged in the pleading is a breach of that section. So.
But they must have purported to do one of those things under subsection 2, mustn't they?
A private law receiver can't be appointed under these powers to take a financial institution into receivership and then deal with its assets and decide what to do with, amongst other objects, the maintenance of the stability of the financial and the banking sector.
That I understand, but if this isn't what happened in this case, then that's not the act we're concerned with. If the act we're concerned with is a sale by a receiver in order purportedly to marshal the greatest amount of the financial institution's assets, see subparagraph 2A, that's the same, isn't it, as the exercise that a private receiver would be doing.
No, again, the act is the act of the central bank entering into that agreement. That is not something.
So sorry, the central bank entering
into the agreement, the P&A agreement. Sorry, then I've misunderstood your Lordship's question.
Yes, quay receiver. The central bank quay receiver entering into the agreement.
No, not quay receiver, quay central bank. All of this is about the central bank's duties, powers, and regulations. So when it
Was that right? This is headed options available to the receiver. It says the central bank shall, within 12 months from the date of taking over as a receiver.
yes, so that's a reference back to section 94(1). And this is going to this is only going to happen, the placing under receivership, if there have been orders under the earlier under the earlier powers.
Do we have the agreement?
Not in the bundle, but it was in the evidence below.
Can we see it?
Sorry, Rod?
Can we see it?
No reason why you shouldn't.
Perhaps somebody could produce it for tomorrow morning.
Well, yes. It does not provide that the bank is the BOU is entering into an agreement on behalf of CBL.
In what capacity is it stated to be instrument?
As the central bank.
That's what it provides.
Sorry, Lord.
That's what it
Oh, I
provides.
see. Sorry, you're asking what the
Or maybe we did just
Let's look,
see
let's
it.
look. So, Laura, I was going to come back to this, but so I say in relation to the nature of the Act, first context, in other words, you can't ignore what has come before. Secondly, in relation to the nature of the central bank entering into the P&A agreement, again, have to take into account the source of the powers, again, back to this legislation. My Lord. Thank you, Lord. Just in answer to my Lord Justice Popplewell's question about what it is said that the pleading in terms of the provisions of Section 95 that are identified and relied on that are then said to have been breached is in paragraph 41 of the amended particulars of claim. Can I just read it because we'll look at it in more detail. Further, under FIA Section 95(2), the BOU was, as receiver of CBL, under a statutory duty to evaluate alternatives and maximise the value of CBL's assets and minimise the costs to the Ugandan taxpayer.
That's A, isn't it? That's, I know it talks about 95(2) generally, but the way that's expressed is breach of or duty to do A, which is the one that's said to have been breached.
Well, could touch on B, could touch on C, that's taxpayers' interest in relation to C, and could touch on D. Would all of those would engage the interests of the taxpayers. My Lord, and the point I was making in relation to the significance of an allegation of breach of Section 95(2) in relation to the Kirkpatrick point is that because the allegation of breach is pleaded in relation to the taking of CBL into receivership and then to sell, that is a necessary, essential part of the unlawful means on which it relies, so that the court would have to determine the legality of the BOU's acts in that respect. Lord, the third feature I identified as a trigger for the application of the Act State Rule is that the claims are in respect of the central bank's exercise of these powers with regard to a domestic Ugandan bank. Again, nothing controversial here. Paragraph 8A of the amended particulars of claim pleads that CBL was regulated by the central bank. Paragraph 1 pleads that CBL, a Ugandan company, conducted retail and commercial banking business in Uganda and was licensed to conduct financial business under the FIA 2004. All of the acts of the BOU complained of were done in Uganda. And then the fourth feature, that the allegations of unlawful acts of the BOU are all allegations of illegality contrary to Ugandan law. And in that context, it is worth noting that it was common ground on the Ugandan law expert evidence below that challenges to decisions or acts of the central bank can be made by way of judicial review in Uganda, as you would expect, in a common law system such as Uganda's. The relevant parts of the reports are in the supplemental bundle. I'll just give you the references. Paragraph 59 of Mr. Kabatsi's report at supplemental bundle page 82, and the claimant's expert agreeing at page 106. That is not, as my own friend suggested, a forum non-convenience point. It is a point about considering the nature of the issues that the English court would be asked to decide in these proceedings, in which the claim effectively seeks to put the English court in a position to decide a series of Ugandan public law issues about whether the Bank of Uganda was justified in making capital support orders, taking it into statutory management, taking it into receivership and sale. Again, indicating that for Kirkpatrick purposes, those are clearly issues that are raised by the pleading and will have to be decided. So, my lord, we say on the face of the pleading, the claimants actually plead for matters that make this a paradigm active state case. Let me come to the specifics then of the application of that in relation to ground 2, the Sovereign Act, and just address the points my lords have just put to me in relation to the P&A agreement in a little more detail. First of all, in summary, we say that this ground fails for 3 reasons. First, even as formulated, it leaves the active state bar to the claims unaffected because the claimants do not and cannot make a claim by reference only to the P&A agreement. The claimants themselves insist that their claim must, on any basis, also comprehend and require determination of their allegations of unlawful conduct by the BOU prior to the P&A agreement. The P&A agreement being, as they allege, the culmination of and founded upon the corrupt scheme as defined in the amended particulars of claim, which includes the allegations of crimes, abuse of powers, and so on, committed by the Bank of Uganda and Ugandan government officials.
Forgive me, you assert that, but why is that so? Why can they not be successful on part of their claim, which is that the receiver sold this company at an undervalue?
Because they've said,
the assets, sorry.
Because they've told the court that they don't want to, can't, and obtain permission to amend on that basis.
And that's not the way it's been argued before us today.
Right. Exactly so, Lord.
You're saying that it's not open to them to argue it the way that they did argue it?
It is not. I'll show your lordship the sequence, but I do say that it is not open to them to say that they can and should be permitted to advance a claim which pleads only in relation to unlawful acts of the BOU, pleads only the entry into of the P&A agreement.
Why doesn't the greater include the lesser? If you have a case of a conspiracy to bribe a receiver to sell assets at a substantial undervalue. That seems to be an entirely coherent, standalone cause of action, which one can discover on current pleadings. It's not plain to me why, if they say they lose on everything else, state or otherwise at trial, I'm not sure why the judge wouldn't be entitled on this pleading to say, yes, I find that there was bribery of the receiver to sell these at a substantial undervalue. And indeed, the claim for damages, it seems to me, is specifically for that. That these assets were sold at an undervalue.
But is your lordship, if your lordship is asking the question, is there a form of pleading which could go forward on a basis which confines the only allegation of unlawful conduct by the BOU as being the entry into the P&A agreement?
Well, it's a very substantial part of their claim, even on the cases presently pleaded. The manner in which the loss is said to have arisen is by virtue of the assets being sold at an undervalue.
This is the sub-paragraph that came in by amendment. So your lordship is saying it's a very substantial part of their claim which wasn't there in the first place.
But it is now,
And which,
but it was there before the judge, as I understand.
this is,
This is all an amendment that was allowed by Mr. Salter, isn't it?
yes. And it came about because the defendants were saying that there was the submitting defendants, so other than us, was saying that the claim didn't work insofar as it sought to rely on unlawful means that had occurred prior to when it was alleged the defendants came in.
Understand.
Right.
How does this differ from Iraqi Airways, in which the allegation was that there was unlawfulness first in seizing the aircraft and then in using them? The court held Act of State applies to the first, and the second was undoubtedly done pursuant to the first, but Act of State doesn't apply to the second.
So, Lord, can I answer that? But I want to very much come back to the.
Sorry, I don't want to take you out of your turn.
No, not at all. But I just
Deal with it when you.
No, I want to deal with that straight away because I can deal with that quite shortly. There is simply no analogue here with the facts of the Kuwait Airways case. In the Kuwait Airways case, Iraq occupied Kuwait airport on the 4th of August 1990 and took possession of Kuwait Airways aircraft, and Iraq, and by the way, Iraq, not a defendant, because it wasn't able to be, well, it was served, but it effectively came out because there was service on the embassy and that was held not to be valid. So one's looking at the question of sovereign act at the immunity stage as between Kuwait Airways and Iraq Airways. Iraq occupies the airport, takes possession of the aircraft, instructed Iraq Airways to look after the aircraft and to maintain them. Then, on the 17th of September 1990, Saddam Hussein issued Resolution 369, which purported to pass title in the aircraft to Iraq Airways for it to incorporate the aircraft into the Iraq Airways commercial fleet and to make commercial use of them. The House of Lords held that Iraqi Airways looking after the aircraft for Iraq in the aftermath of the taking was sovereign, and then the commercial use of them once it had acquired title, which had been given to them in order that they should make commercial use of them, was commercial. There was a distinct and clear change of the nature of Iraqi Airways' dealings with the aircraft from the 17th of September 1990. So the context, which Lord Wilberforce emphasised, must be looked at and taken into account in assessing the nature of the Act. The context of the pre-17th September use, the wrongful interference, which was the subject of the claim, pre-17th September, the context was the invasion, the occupation of the airport. entirely different to the context of the post-17th of September use. There is simply no such break or change in the facts on the claimant's pleaded case here. There is no break or change in context or change in what the BOU was doing. It was all one process. The claimants say it was a sequence of steps that the BOU was set on doing using its suite of bank resolution powers.
Well, that really depends, doesn't it? You can say it was the powers up until the point at which they enter into a private sale. And a private sale is a private sale. It's a different context.
But the context didn't change. The context of what the BOU was doing didn't change at all.
Well, up to the point of the sale, everything they're doing on your analysis was pursuant to their role as a central bank. At the point they sell an asset, they're selling it just like anybody else can sell an asset.
No, but that's not what the claimants say. The claimants say that the whole sequence was what the BOU set out to do in the first place. So the context, if one asks on the pleading, what is the context of each of those steps, including the sale, the claimants say it is the corrupt scheme.
I doubt whether the Iraqi seizure of the aircraft was to keep them in a museum. Right from the start, they wanted to have the aircraft.
No, I'm afraid that's not correct, Lord, at all.
I'm sure you know better than I do.
No, but the airport was occupied as part of the invasion. So they were in occupation of the airport. KC had 10 aircraft there. There wasn't a setting out of what to do with them at that stage. So all that happened, that's in a sense the point, yes, as to what Iraq Air was
doing.
And
they took them to...
In terms of, from the assessment of immunity, the next significant act was the passing of the resolution which transferred title. And that was, the form of resolution was effectively that therefore they would be incorporated into Iraq Airways fleet. So there was a complete break, complete distinction in context. Here, there is no change in context. Let me deal with, if I may then, just on this point, the other authorities my own friend referred to. The Banco Nacional de Cuba case, Mr. Justice Lightman's decision. He read you the passage where Mr. Justice Lightman emphasised that this is it was at Authorities Bundle 2, tab 10. He read you the passage where Mr. Justice Lightman emphasised that his finding that the sale by the bank of shares in a subsidiary was a commercial act was made in circumstances where there was no evidence before him that the sale was pursuant to any legislative or executive direction. Whereas the reorganisation which had preceded it and was distinct from it had been affected by legislation. So again, there was a clear break in context, the context changed. But here the pleaded case is that the P&A agreement was being made pursuant to and as part of and in culmination of their word, claimant's word, and in culmination of the same statutory process and in precisely the same context. Takeover, closure and sale, as they put it and pleaded.
I know the sale in Banco Nacional was in time a little later, but Mr. Justice Lightman treated it as being part of the reorganisation.
No,
did he not?
No. He treated it as having happened. It could only happen because there had been the reorganisation.
Should we have a look at it?
Yes, certainly. He says, so volume 2, tab 10. Bundle page 357, paragraph 28. And you see, it says in paragraph 28, on the other hand, BNC and BCC entered into what was in form a private law contract and completed it as such. There is no evidence that the sale was pursuant to any legislative or executive direction. In this respect, the agreement is in a quite different position from the rest of the reorganisation, which was affected by legislation. In the language of Lord Wilberforce, everything was done as between vendor and purchaser. There was no exercise and no need for exercise of sovereign powers. The private law character of the transaction is not discoloured by the context in which the agreement was executed, i.e. the fact that the parties to it regarded the transfer of shares to BCC as an obvious and necessary sequel to the statutory organisation, but not part of the statutory reorganisation. And then motive not relevant, which is obviously correct. Just to finish, maybe just to finish off the sequence of authorities referred to, and I would suggest, my lords, that there is probably a limit to the assistance one gets from looking at first instance cases which don't establish any different principle. Miss Justice Lightman, of course, was just applying Lord Wilberforce in the prior lager. So there is, as I say, a limit to how far the fact comparisons can take one. I would suggest that actually even less assistance is to be obtained from US district court cases such as AMPAC and WMW machinery, which were considering the application of the United States Foreign Sovereign Immunities Act, which is obviously not the same as our State Immunity Act, though one sees that there are some similarities of approach. But again, the search for similar fact patterns rather than some statement of principle is perhaps not hugely productive. I would note that if the court did want to look at US cases that are rather closer factually, the appellants in fact cited in their skeleton a case, Murphy, which is a bundle 8 tab 44, which my friend didn't take you to, but is in fact factually a much closer analogue. Their claims were made by the plaintiffs against a Korean government entity, CAMCO, that had responsibility for managing certain government assets, bonds, assets, to maintain financial stability in the banking sector. The plaintiffs were making claims there for false representation in relation to its unsuccessful attempt to purchase assets of a bankrupt Korean company that CAMCO was responsible for. And it was held by the District Court, Southern District of New York, that CAMCO was a sovereign entity and that the claim did not relate to activities falling within the commercial exception in the Foreign Sovereign Immunities Act. The reference in the judgment is, the relevant pages are 2298 to 2299. But at the end of the day, it is just another US first instance decision on another set of facts. My lords, I want to come back, if I may, to this question of as to whether the P&A agreement can be looked at in this context separately. Just to be clear, in terms of the law and the relevant test, we agree that it is the nature of the act that must be considered, not the motive for it. Second, a point that we do emphasise, that the context must be considered. As Lord Wilberforce said, the court must consider the whole context in which the claim is made. and should in that context consider whether the area of activity is of a private law character or is within the sphere of governmental or sovereign activity. And that, in my submission, requires the court to look beyond the fact of an agreement and to consider the nature of the act. The nature of the act is the nature of the central bank's entry into the agreement in the context that it's the area of activity in which it is operating.
I say, for my part, I find it increasingly academic to talk about this agreement without seeing it.
Right.
I tend to agree with that.
Well, in which case, I will.
Somebody,
I'll come back to it.
could somebody be sent to go and fetch it so that when we have a break at 10 past, we might have it at 15 past? The solicitors must have it in their offices somewhere.
No, indeed, it's in the
trial bundle.
it was in the bundles for.
It just needs to be photocopied by somebody.
We have a copy. I don't know whether it would be quicker to get the clerks to copy it or whether the court would copy it.
It's been done.
Well,
Oh, you have it.
Excellent.
good. Well, somebody's done their job already. Very helpful. Thank you.
Let's go.
This is where you find the one you've been looking at is completely different. Yeah.
My lords, I I won't make. I don't think I should make submissions on it.
Why don't you think about it overnight, Mr.
Lord. Yes, and identify the parts which are.
What are you trying to do with it all?
No, that would be more would be preferable. My lord, in terms of the claimant's characterisation of the acts of the BOU, and in this regard, my lord, I do say and continue to say that the court has to have regard to all of the acts of the BOU that are relied on, and which, as we understand it on the basis of what you told yesterday, it is accepted were sovereign other than the P&A agreement. My lords, and to come back to the question my Lord Phillips raised with me, and the question as to what the claimants are and are not permitted to do. First of all, when you are looking at the amended particulars of claim, there are two things to bear in mind. The first is that it was amended, substantially amended, after the jurisdiction application had been issued and the Act of State issue raised and the objection, the basis of it articulated, with the hearing of the jurisdiction application pending shortly after the ultimately the permission to amend application was determined.
Yeah.
And the reason for that was because with the various applications that had been issued, Mrs. Justice Cockrell, then the judge in charge of the commercial court, had ordered that the amendment application be heard and dealt with before the jurisdiction challenge, so that the jurisdiction challenge could be considered by reference to a settled position in relation to the amendments. The second point that I emphasise is that the commercial court guide, of course, in paragraph C1.1e says that special care should be taken to set out with proper particulars only those factual allegations which are necessary to establish the cause of action being advanced. So the court can take it as we look at the factual allegations that are relevant to the question of the sovereign characterisation of the acts alleged and relied on, that the claimants carefully considered and assessed that each of those matters was a necessary fact to plead to establish their cause of action, none of which have been withdrawn, none of those have been adjusted down, either in the face of the Act of State challenge or at the time of amendment or before the judge below.
That assumes that the pleading complies with the commercial court guide, which it may or may not. I'm not sure where that point takes you. I mean, you'd have to go through the pleading line by line, as it were, and say, well, that allegation is critical, that allegation is critical, etc. I mean, we see plenty of pleadings in this court which are, go beyond what is entirely necessary for the purposes of pleading the cause of action.
Well, my lord, it's the claimant's pleading. I'm sure they would. I hope they would tell you that they consider they've complied with the commercial guide. The point is, my lord, that again, in terms of identification of relevant facts of the context that falls to be taken into account in relation to the Sovereign Act question, the court can, in my submission, must take that on the basis of and so, my lord, just to identify certain parts of the pleading, Core Bundle tab 7. Page 95, paragraph 8C. The corrupt scheme is defined as a corrupt scheme in relation to the takeover and resolution by the BOU, so that comprehending the entirety of the process. You see that even more clearly in sub-paragraph E. This is their pleading in relation to the P&A agreement. The execution of the P&A agreement and the steps taken thereafter to put it into effect were the culmination of the corrupt scheme.
Which paragraph is that?
Sorry, my lord. This is paragraph, the bottom of page 90, bundle page 95, paragraph 8E. Tab 7 in the core bundle.
Yeah.
8F. Oh, sorry, and I should have shown you over the page. The P&A agreement represented a sale of CBL's assets and liabilities to gross undervalue and followed a sham bidding process orchestrated by the BOU, by its officers and or agents in breach of trust and of its and their fiduciary duties to CBL and of provisions of the FIA and an abuse of office. Again, each time the claimants pleading that the P&A agreement, pleading facts and allegations that put the P&A agreement in a wider context, looking back to the process that has come before. No, that's a wrong reference. 15, paragraph 15. And that now this is for in terms of the earlier steps, again, all clearly sovereign acts. Paragraph 15. Pursuant to the corrupt scheme, the BOU did not give the claimants the opportunity to raise additional capital, instead took steps deliberately to inhibit their ability to do so. In order to ensure that CBL had no cash flow and developed a liquidity crisis, the BOU took the following prejudicial steps that eventually led to the takeover of CBL. A, withdrew CBL's authorization to conduct most financial business, obviously not something that a private party could do. B, the BOU ordered CBL to raise a further 88 billion Ugandan shillings, again, not something that a private party could do. D, second sentence, the BOU refused to allow this sum, that's additional capital, to be injected into CBL and instead insisted that it be held on deposit at the BOU. Again, not something a private party could do. Paragraph 19 on page 102. CBL applied for emergency liquidity assistance of $115 million from the BOU as a lender of last resort. 4 lines down, the BOU purported to consider and reject the application on 17th of October 2016. Same point, this is all quintessentially part of and relating to the BOU's powers of bank resolution.
But as you say, none of this is in dispute.
No.
But it is the context. And because it is the claimant's case. And so, however many times, my lord, it's suggested to me that if you looked at the P&A agreement by itself in the abstract with no other context, then it might look different. My lord, my answer will always be the same. The question has to be tested against the claimant's case. The context is the context that they plead.
Well, is that really right? That plainly they plead the chronology of events, which leads up to a number of assertions of causes of action and plead causation and loss. Surely, when it comes to looking at what is or is not within the commercial exception, one has to look at the reality of what happened and what is alleged to have happened to determine which parts of it can be said to be fall within that exception. I think saying, well, they pleaded all of it, that's the context, so therefore that's the end of the game. I'm not sure it's that simple.
No, Lord, when I say they pleaded, they're not pleading it as a chronology of events. They are pleading these matters, and attached to each of them is an allegation of breach.
Well,
And they are all pleaded as part of a singular
I understand that, but
corrupt scheme.
plainly, at the stages you showed us, the defendants weren't even involved.
Exactly.
So it is background and it is chronology, isn't it?
The nature of the BOU's acts doesn't change according to when the defendants came on the scene.
No, I understand that, but
I mean, that's
to say that to trawl through all those matters and say, well, these are all statutory functions of sovereign nature doesn't seem to me does assist us when we come to look at the crunch period when defendants become involved. And it seems to me that there's no doubt that one can argue, this is what the debate is, that one can argue that the gist of the claim at that point is that the defendants themselves acted wrongfully by offering bribes and other wrongdoings, as a result of which the receiver happens to be appointed themselves pursuant to statutory functions, has sold assets at an undervalue. And the case against you is that looking at that specific core aspect of the claim.
In a vacuum. In a vacuum. Looked at
You
that
can say
act.
it's a vacuum, but the fact is that is the core of that seems to me to be the core of the case.
But that has no
And is that
context.
sorry?
None of these other matters, all of which precede the involvement of the defendant, are alleged against the defendant, are they?
That's the point, my lord. But that is of course.
Because the defendant only becomes involved on such and such a date.
But that's what that of course is at the heart of the act of state objection. The whole point is that it's allegations of illegal
Well, I
conduct.
understand that point.
Right. So, but let me.
If I was looking at my lord's point to you, which is that this is all, if you like, part of the background.
It's not, my lord. It's not part of the background. The reason it's not part of the background is because the claimants plead and insist on pleading, and through the amendment application absolutely asserted the need for them to plead
I understand that point.
the corrupt scheme. It's not background, it is not chronology, it is foundational of their case. But my lord, let's look at one which is in relation to a matter after DFCU came on the scene. Paragraph 39.
Of the pleading.
Of the pleading, page 113.
Yeah.
And remember, this is the point that my own friend emphasised yesterday. This happens after DFCU on the scene.
Yep.
The BOU transferred CBL from statutory management into receivership on the 24th of January 2017. It was necessary to transfer CBL into receivership in order to give the BOU the power to sell CBL's assets and liabilities under FIA section 95(1)(b) to its identified buyer, DFCU Bank. The claimants aver that the movement to receivership was done in bad faith and just as a formality, and so on, in order to conceal wrongdoing. And then we have the other paragraphs that I mentioned earlier, paragraph 41 referring to FIA section 95(2) and breach, then in paragraph 45, breach of those provisions. That is a matter where they are alleging unlawful conduct in relation to an act, that is the transfer from statutory management into receivership, which is obviously sovereign, which they concede is sovereign, and which they raise not only for determination if the proceedings go ahead, but as the context of what then comes in terms of the P&A agreement. It is, in my respectful submission, impossible to consider the nature of the P&A agreement divorced from that context which they plead. And Lord, there are other parts of the pleading where they themselves are emphasising the Bank of Uganda's central bank function and powers that permeates right the way through to the breach, through the breaches that are alleged by the BOU and which are pleaded as part of the unlawful means.
Is that any more than saying there were a series of separate acts, but there was always a constant and single motive that informed all of them?
It is not saying that, Lord. It is saying that that sequence of sovereign acts were in nature all of a piece. There is a single
because they all had the same objective.
No,
which was
Lord,
ultimately.
it's not a no, Lord. It's not a purpose point.
Well, what is it then?
What is it then?
It's because they are all being done pursuant to the powers, and the allegations of breach are in relation to the relevant source of powers is the central bank exercising its functions. Put another way, if all of those acts are sovereign, then in my submission it is not possible to identify any reason why the nature of the P&A agreement can be different from what has come before. There is no break in context, there is no change in context. context used in the correct sense as used by Lord Wilberforce in Lager.
Thank you.
And Lord, if we can look at the notorious 69M,
Yes.
and actually see whether whether there is a break, a clarity of distinction between the treatment of the P&A agreement and what has come before. What you see is that there is not. On the bottom of 128, and apologies, I keep saying subparagraph 69M, and that is important. It is not a freestanding sentence. The chapeau at the beginning of 69, page 125, pending disclosure, the claimants have identified the following as unlawful means by which the conspiracy was effected after the defendants joined the corrupt scheme or alternatively became parties to a new conspiracy. I will come back to the alternative new conspiracy point because that was misdescribed to your lordships yesterday, but for the moment, please put that on one side. That is the introductory wording to the subparagraphs. And then if we go to M, at the bottom of 128, the offer by DFCU Bank to enter into and the entry by DFCU Bank into an agreement and transaction with BAU with the features and for the purposes identified in subparagraphs A1 to 4 above. Features, obviously relevant to a question of nature, purposes not so. Go back to A1 to 4. A, abuse of office on the part of BOU, including by exploiting powers, positions and responsibilities as statutory manager and receiver. A1, and then you have the commission of the tort of misfeasance in public office, committing the crime of corruption, committing the crime of bribery, committing the crime of abuse of office. So that is an incorporation as the starting point for M, taking one straight back to the matters that have come before. Which conduct, then they say, which conduct amounted to the crime of corruption. You then have the plea of the 100 billion, crime of corruption in 2, crime of bribery in 3, crime of causing financial loss, etc. So even within 69M, the claimants are pleading and relying on what they say are features.
These are all particulars of unlawful means, which post-date the arrival of DFCU, is that right? And they seem to.
No.
Well, some of them, well, that's why I asked the question, because it's a bit confusing. But I noticed, for example...
Lord, can I just interrupt your lordship a second?
Yeah.
Your lordship says it's a bit confusing.
Yes.
Yes, it is a bit confusing. This is what prompted the issue around the amendments, because the point was being made is, how can you say, as a matter of law, how can you say that you can have an unlawful means conspiracy to which defendants join, where the unlawful means you rely on are matters that have already taken place prior to the allegation.
Well, that's why subparagraph B on page 127 has been deleted by amendment. Because that's the statutory management, so that precedes the arrival of your clients.
So this was one of the key questions. And of course,
the point you were making a moment ago.
Can I show your lordship how this was dealt with?
Yeah.
So instead of then spelling out in the amendments some explanation for how this works, what we had is two things. First of all, paragraph 69A at the top of 130.
Oh, yes.
And then we had the claimants' submissions to the judge hearing the amendment application twice, in which they clarified and made submissions upon which the judge relied in granting permission to amend, which made clear that they were still relying on those matters which had come before. And that, can I just show your lordship, because it is off that, and it is because permission to amend was given on that basis. That is one of the reasons why we say it is not open to them now, in the context of an act of state discussion, to say, oh, well, actually look at some lesser part.
Right.
Now, can I just...
Sorry to press you, is the answer to my lord's point that once amended, these unlawful means are all post-DCFU involvement?
Some of them began before, that's 69A. But what's relied upon is either by way of new conspiracy or continuation. They continued or reoccurred thereafter. So it's like a continuing breach or a recurrent breach after the involvement of DFCF.
I mean,
unclear, it's very, very difficult to tell, because, for example...
Well, isn't that what the introduction to, the amendment to the introduction to paragraph 69 says?
Yes, yes, but...
And so everything that comes underneath, so A might be unlimited as to time, but in the context of the introduction, it's clearly intended to be the steps which postdated the defendants joining the corrupt scheme.
Yes, so, but then, since, for example, I'm not sure, Lord. I mean,
Well, perhaps if you can identify any that are clearly pre-DCFU alleged involvement, you'll come back to us and
I don't know whether there is for example, a question mark in relation to statutory manager matters, because those of course ended. Is your lordship is asking about the whole of 69?
Yeah.
Yes.
Well, 69A says for the avoidance of doubt,
Yes.
what we rely on is what happened afterwards.
Yes.
Because it continued.
Yes.
Even though it was happening before, it continued after. So I suppose there was a scintilla of time when, if you look at C on page 127, a breach on the part of the BAU of its obligations to exercise its statutory management function to seek to return it to compliance with prudential standards. There was a scintilla of time
But
when it
for-
was still statutory manager after DFCU had been, as it were, lined up before they switched to receivership.
That's clearly what the claimants are trying to do. I accept that,
Yeah.
and in a sense, that's a point in my favour on this point, which is because it emphasises the inability to separate the claims in relation to the P&A agreement from the allegations of breach by the BOU that started before and that they say continued.
Is that a convenient moment to take a break?
Lord, yes, of course.
5 minutes then, please.
All right. Lord, can I just pick up two additional points on the pleading, again relevant in the same way. The first is to note that in 69M and indeed in a number of other subparagraphs, that you will see, if you look at 69, bottom of page 128 going over to 129, at the end of 69, at the end of 69M1, you will see that the unlawful means pleading also relies on, so it's not just the P&A agreement, but also, you see the words 3 lines from the end, including the selection of DFCU Bank as the purchaser, the placing of CBL into receivership, and the entry into the P&A agreement, the BOU facility agreement, and the side letter. Obviously, the placing of CBL into receivership is a incorporation of allegations in relation to that Sovereign Act. The side letter is interesting in terms of the way that is described. If you go back to page 119, paragraph 56.
56, yes.
Perhaps, can I just ask your lordships to just and save the transcriber's fingers for a moment, just to read through paragraph 56. So obviously important that the unlawful means, even within 69M, is also making allegations in relation to the side letter, all of those matters being separate from the P&A agreement and clearly of a sovereign nature in relation to what the BOU were saying by the side letter the DFCU could do in terms of it, for example, affecting its position in relation to compliance with FIA requirements and reporting matters. And the other point is to show you...
So are you saying you have to take the P&A agreement with the side letter, and the side letter is clearly exercising regulatory capital requirement
Yes.
functions?
Yes. And the reason you have to take it with the P&A agreement is because
It's all part of the sale price.
it's pleaded in the same collectively. Receivership, P&A agreement, side letter, all pleaded within this subparagraph, which therefore could not be, and this comes back to my Lord Justice Phillips question, if the question is, could there be a pleading which pleads only the P&A agreement? I would say no. I'll come in a moment to the question of whether that could be, why that couldn't be permitted. But in terms of the way this is advanced, even 69M is not a pure P&A agreement claim in terms of identifying its unlawful means. The other point, relatedly, is just to, and this is also interesting, because again, your lordships, for act of state purposes, have to consider what is it that the trial judge would have to decide.
Yeah.
If you go to, it's quite interesting to look at what the claimants say about causation and loss. Page 145. Paragraph 84B. But for those unlawful means, so that's a collective reference to all the unlawful means pleaded, but for those unlawful means, either one, CBL or its assets and liabilities would have been sold at a proper price, or two, CBL would have been taken out of resolution measures and would have continued to operate as a financial institution under the control of its board of directors and shareholders. That is positing a counterfactual which necessarily has to go back and well back beyond the P&A agreement.
Right. So 84A identifies the unlawful means that are being talked about as those in paragraph 69, which, subject to the point you're going to come back on, are post-DCFU involvement.
Yes.
But for those unlawful means, i.e. post-DCFU involvement, Roman 2 posits a counterfactual which deals with the position when DCFU had become, allegedly, a conspirator, but it was still in statutory management. And there was such a period of time, I think of several months, wasn't there?
But the counterfactual posited is that it would have been taken out of resolution measures.
Yes. Because it was at the time that the unlawful means are first alleged as against you, it was in statutory management still. And it could have been, the statutory management powers could have taken it out of resolution. That's what you say should indeed have happened. The claimant saying it should have happened.
Yeah.
My point, and I'm apologising, Lord, for a complaint.
It's my point if I haven't made myself
my point is that the counterfactual is requiring the thinking away of matters which are accepted to be sovereign.
Sorry, accepted or what?
To be sovereign.
Yeah.
So in other words, you have the problem of consideration of sovereign acts, not only in relation to the primary parts of the case in relation to the allegation of unlawful means, but that is going to come back again in relation to the causation case.
I misunderstood.
Yeah, okay.
That's my fault.
This is the separation of the P&A agreement point, which is their case, even in this respect, in relation to causation, necessarily pulls things back to consideration of the earlier.
That's their alternative case. As I understand it, 1 or 2.
Yes.
There's no reason, is there, why you? There are many reasons why you may not be able to run your preferred case or your alternative case. And here we have a situation where the claimants are saying none of what they plead is subject to act of state because of public policy, Article 6 or Kirkpatrick. They have a narrower exception, which is commercial. As with any case, they may fail on some of their arguments. They may ultimately fail on public policy, and be left having to argue commercial. So I'm not sure why you can say that they should not be entitled to plead and rely upon the broader framework on the basis that they have the other exceptions to act of state, and that in some way prevents them relying upon the narrower act of state exception.
The commercial issue and the exceptions are different. The question, if the first question is there reliance on acts of state, and if they're sovereign, they're acts of state. If they're commercial, they're not acts of state.
They say there's no problem with that because
Yeah, that's what my lord's putting to you. What
They
he's
say-
saying is even if they were sovereign acts, the public policy exception applies, and that's the argument that's right.
With public
This is
policy
all part
exception.
of a corrupt scheme. I mean, those very words, Lord Panic would say, indicate this was corruption. Now, you're going to have to deal with that, and you may be right, you may be wrong, but assume that we were to allow that point to go forward to trial.
Well,
At trial, the judge might find that was corruption and there was a public policy exception that did apply, in which case the claim would succeed, irrespective of whether or not these were sovereign acts. On the other hand, if they lost at trial, then they, the point my lord's putting to you, they'd be thrown back on, I suppose, Kirkpatrick and on this point about commercial acts. But if part of what they, I mean, I follow your point. This is all part of a sort of continuum, and you can't dice it up. But just assume that you can. If you can say, well, the sale is different because that is a commercial. That's something a commercial receiver could have done. Why should they be deprived of the opportunity to, as it were, fill in the background to that by reference to all the other matters?
Lord, but point one that I've addressed, it's not a filling in of the background.
No, I understand.
Point two, if the court decides that a claim is made based upon, not a matter of chronology, not a matter of narrative, based upon alleging that an act which is sovereign is unlawful, then the act of state principle is engaged and the claim can't proceed in respect of it. That is subject to exceptions. I will obviously address the question whether the exception issue should be decided as the judge did at this stage, as your lordship did in Koza, or is a matter for trial. But if the exception doesn't apply, then then the matter doesn't proceed.
Yeah.
If the matter goes forward to trial, if all the act of state issues are left to trial, which we say is a wrong approach in principle, but if they're all left to trial, then obviously everything is then in play, and then the trial judge would then have to work through that sequence of deciding first whether the matters are acts of state within the act of state principle, secondly whether any exception applies.
I think my concern though is that you're looking at 84B. It seems to me that the first of the two alternatives, CBL, all its assets and liabilities, would have been sold at a proper price.
Yes.
That seems to be a fairly unobjectionable plea of causation and loss
Lord, I agree.
on the basis of the commercial exception.
I agree.
Then you come on to, but then you say, but then they have the second limb, which is, you say, goes further than that and opens up sovereign acts. But my point about that is, yes, but they are relying upon the other exceptions to the Act of State doctrine, so why shouldn't they plead an alternative on that basis? And why does the inclusion of that alternative in some way undermine their entitlement to rely upon the commercial exception, for which alternative Roman 1 would be a perfectly acceptable plea?
That wasn't my submission, and I apologise. It's my fault. I was, and terminology may be important. It's not a commercial exception. There isn't an exception to the Act of State principle. It is an ingredient of establishing Act of State.
But it's
The Act is a
the
sovereign
in
act.
question of commercial acts rather than sovereign acts.
If the Act is commercial,
Rather than sovereign.
then it's not an Act of State.
Then it's outside the doctrine. That's the point.
Yes.
Yeah.
So, but to answer my lord's point directly, and I'm sorry if I was not clear. I wasn't suggesting that that alternative plea creates some new freestanding sovereign act argument.
No.
I was making the point that if one considers, because of what's been pleaded in 69M as to the unlawful means, and because that includes the putting into statutory management and the putting into receivership, which are sovereign acts, one can see that the causation case pleaded is going to involve, within the counterfactual, the considerations, the sovereign consideration, the problem, the Act of State problem about considering not only whether the Acts of State were unlawful, but also as to what would have happened by the Bank of Uganda in exercise of its powers if it had acted as it suggests lawfully. My Lord, it's not a big point, and I'm sorry if I've set a hair running.
Just by way of reference to exceptions, I think the way it's put by Lord Lloyd Jones at 136,
Yes.
there are limitations or exceptions, and each of them are described as the doctrine will not apply to it. I'm not sure that there is a particular difference between the two concepts.
Between limit and exception. Lord, certainly there isn't a difference that matters. It might perhaps go to the order of issues, in the sense that,
Well, but the just on public policy point,
yes,
it could be said that if the if the act is so egregious that the public policy exception applies, it might be said it's incapable of being a sovereign act at all because it's so egregious.
no,
Which is sort of the Catamol point.
no, my Lord, that's definitely not the case. And the reason, and it is important in that regard that the public policy exception is a true exception. In other words, ex hypothesi, there is an act of
There
state.
is a sovereign act, okay.
And the reason why it is important to approach it on that basis is because to identify a relevant public policy, one has to ask what is it that the court, under the Act of State principle, is required not to decide, to abstain from deciding, then to consider whether there is a public policy which then overrides that and requires the court to consider it.
One of the cases talks about abstention, doesn't it? I forget which one it is.
I'm going to come back to that. That's very important. But in relation to commercial act as a limit my lord, I accept that it can be seen as a limit, and that doesn't nothing turns on that. My lord, can I just because I keep saying I will come to it, and to the point about why why it's not open to the appellants to to go back on their characterisation.
Is this the submissions that were made to Mr. Salter?
It is.
Right.
And so, can I show you first the relevant submissions and then the relevant parts of Mr. Salter's judgment? Supplemental Bundle 1. Tab 4. So this is the 7th of April, and so the sequence, as your lordships may have picked up, the sequence was that the amendment application was directed to be heard at the first CMC, which was on the 7th of April. As a result of the judge's indications at that hearing as to, let me put it as, his concerns about the pleading, the claimants were given an opportunity to go away and replead, which they did. The defendants, the active defendants who were addressing the pleading issues indicated that they would not consent to the further amendments, and then that came back before Mr. Salter on the 5th of May. So this is first of all looking at the claimant's submissions, known for Ms. Brown, in relation to the pleading pre-amendment. First of all, at bundle page 30, transcript page 100. Maybe sort of picking it up on page 99, line 17, Ms. Brown is addressing the pleading. The first sentence, it repeats the definition of the corrupt scheme and then says it is not limited to the attempt to sell CVL to CEFC. On the basis of the information the claimants have at present, it's not alleged that any of the defendants were involved specifically in Bank of Uganda's attempt to sell to CEFC. It is alleged that defendants became involved in the corrupt scheme as defined after CEFC pulled out, which is after BOU had placed CBL into statutory management. And then my own friend said, so there again, it's very clearly put that the defendants became involved in the corrupt scheme at that point in time. As your lordship has already observed, the corrupt scheme is a continuum from the inception, which involves the Chinese to its conclusion, which is the P&A agreement and related agreements through which a single thread runs, being the involvement of Bank of Uganda, but with the Chinese stepping out and DFCU stepping in, my lord. It is not correct to suggest that the early part of the scheme before DFCU was involved is somehow irrelevant to the actions of DFCU and what is alleged against them. And then top right quadrant, page 101 of the transcript, line 22. So, my lord, what we see is that the nature of the corrupt agreement, including the concealment of the wrongdoings in relation to the takeover of CBL at the outset of the corrupt scheme, in those circumstances, it is simply unfathomable to suggest that the early stage of the corrupt scheme is not relevant to the overall case against the defendant. And then over the page, the bundle page 31, transcript page 103, line 20. I'm grateful to say, my lord, we submit that at that very early stage, the court should be slow to adopt too mechanistic an approach as to whether the case involves a single overarching conspiracy, the corrupt scheme in which the Chinese were originally members, dropped out and were replaced by DFCU, or two separate conspiracies, with the joinder of the defendants representing a fresh conspiracy. Whether the analysis is one of a single overarching conspiracy in relation to the takeover and sale of CBL or its assets with BOU at its heart, or two separate conspiracies, whereas here it is alleged that the defendants became parties to the conspiracy after certain wrongful acts were done, but in order, at least in part, to cover up those earlier wrongful acts, there cannot be a bright line test excluding as relevant the unlawful conduct before they joined. And then on the right, top right transcript, page 105, line 10, my lord, no useful purpose would be served by a striking out reference to Bank of Uganda's unlawful conduct at 69A, which predates the defendants joining the conspiracy. It will not reduce the burden of preparing for trial or in any meaningful way impact the issues to be determined at trial. The court will still have to determine whether the Bank of Uganda acted wrongfully during the earlier part of the unlawful scheme in order to consider whether part of the purpose of the sale to DFCU was concealment of those alleged wrongdoings. So, not severable. The issue can't be avoided by a contraction, all one continuum. Now, that characterization of the pleaded case was accepted by the judge hearing the amendment application as the reason and basis for giving permission to amend. And you can see that at tab 6 in this bundle, supplemental bundle 1. Sorry, apologies. I've missed out the sequence. Sorry. After that, the claimants went away and brought forward their amended pleading, and then that came before Mr. Salter on the 5th of May.
Yeah.
With the defendants objecting, and you have extracts from the transcript of that at tab 5. My own friend, Mr. Kaplan, was appearing for the claimants. And if you would go to bundle page 37, transcript page 54, bottom right of the page, this was he was addressing a point about considering 69M on its own, and you will see at line 20, my own friend said, it is specifically about pleading rather than proof at trial. That will become particularly relevant when we get to the 100 billion point, but you see the point being made essentially that you do not consider whether a pleading passes the test, as it were, by salami slicing it. You look at things cumulatively and then ask whether an inference of dishonesty is more likely than one of innocence or negligence. And then, if you would turn over to bundle page 39, transcript page 59, top left, line 6, dealing with Mr. Howe's point, it just comes down to terminology and how broadly or not one defines the corrupt scheme. If one defines it as it is defined in 8C, it is broad. The aim of the corrupt scheme was to take control of the Ugandan bank and sell it, or in the event its assets and liabilities for corrupt purposes. From our perspective, and no doubt from the Bank of Uganda's perspective, it was all a continuum. That does not mean that if we say on our primary case the defendants joined it, they are liable for everything that happened before they joined. No, we have made clear they are not. But it just becomes a question of definition. Is there one conspiracy or two? And then on the right-hand side, top right, page 61, line 4, as to the point of what the relevance of the first stage, if I can put it like that, of the corrupt scheme is, it is clearly relevant on either case being the primary conspiracy or the alternative with the joining two conspiracies. You cannot possibly understand, even if one were to view the second stage, as it were, as a completely separate conspiracy, the case without understanding what led to it, and indeed that it was part of a wider course of conduct that was being carried out by the Bank of Uganda. And then
You need to read on, don't you, in the paragraph.
yes. But in other words, yes, he was saying we can plead it as one conspiracy or we can plead it as two. But even if we plead it as two, the earlier matters, the earlier allegations against the Bank of Uganda, the earlier conduct of the Bank of Uganda are still equally relevant and will have to be considered, and the issues arising from it will have to be determined.
At that point, there would be no, it would not be necessary, it would not be the primary aim of the litigation to determine that those matters were illegal. They would only be background.
No, my lord. No, that's exactly the opposite of what they were saying. They were saying you would have to, you would still have to, because the unlawful means would still be, as we've seen, would still be the, in terms of what was relied on, would still be the same.
But it wouldn't be necessary at that point to determine that they were unlawful.
It would. Because it would be necessary to determine whether the means were unlawful. Can I just make sure? So you'll also appreciate what my own friend said yesterday about the alternative conspiracy case being a conspiracy only of the defendants is not correct. The alternative conspiracy case. So
I didn't understand him to be suggesting that. I just understood him to be suggesting that the allegation of conspiracy does include, and therefore it would be sufficient if there were only found at trial to be sufficient amongst the DCFU defendants, which did not involve the Bank of Uganda. He was suggesting that that wasn't, that was the way the alternative conspiracy was put.
Impossible, my lord. Impossible. The allegation of the primary case, one conspiracy, the alternative case, two conspiracies, but the second conspiracy being of the DFCU and the defendants joining with the BOU.
I understand that.
But it would be impossible.
As opposed to the first conspiracy being the one between the Bank of Uganda and the Chinese.
To which
hypothesis.
the DFCU come in.
Yeah.
On those alleged facts, you couldn't, a case that only the defendants were party to the conspiracy would be inconsistent with the pleaded allegation of conspiracy. And that is absolutely clear from the amended pleading. Sorry, just forgive me one moment. I will. This is important. I do apologise. I've just lost the reference to the.
It wouldn't work without the involvement of BOU, would it?
No.
No.
And
Well, it's paragraph 68. All parties to the corrupt schemes necessarily.
Thank you,
Bank
Lord.
of Uganda.
thank you.
Alternatively, they formed a new conspiracy with the BOU.
Thank you, Lord. Yeah, exactly that.
So is your case on the one conspiracy case essentially that you can't join an unlawful means conspiracy unless there is an unlawful means conspiracy going on before you join. And therefore, you have to look at whether there was one at that stage.
That was sort of the objection that was being made on the amendment application, on the amendment application first time round, that you couldn't plead a claim of a single conspiracy relying on unlawful means which had already been carried out prior to the joining in of the defendants.
No, I'm on a slightly different point.
Sorry,
I'm obviously not putting it carefully. As I understand it, the part of the argument you've just been showing us now, Mr. Kaplan was addressing a suggestion that it had to be pleaded as two separate conspiracies. It couldn't be pleaded as a single conspiracy, and he was saying, yes, we can, because it's you can frame the conspiracy and it's all a continuum.
No, that's not the point I was making, Lord. So the point I was making was that the claimants, in saying that they should have permission to amend, were making it clear that whether it was their primary single conspiracy case or two conspiracies, in either event, that would involve necessarily the consideration by the court of the unlawful acts of the BOU in the earlier stage prior to the defendant becoming involved. So in other words,
You weren't making a separate point that just vis-a-vis a claim put as a single conspiracy, that whatever they said in these submissions, that must necessarily require determination of whether there was an unlawful means conspiracy before it was joined, because you can't join something that isn't an unlawful means conspiracy if what's being alleged is it's a single conspiracy.
I wasn't making that point,
Right.
but I was making in a sense more, which is that your lordship is a legal analysis, and my point is on the basis of what the claimants were telling the court would still have to be determined even on the alternative basis.
Yeah.
And the point of that is that if one is trying to understand, for the purpose of act of state, what is it that the court would have to decide, and would it have to look in any event, even on some attempt to limit the case to the P&A agreement, because it's actually less than 69M. The claimant's position was, as a basis for obtaining permission to amend, that all those earlier matters would still require to be determined. So in an act of state relevant way, that the court would have to determine the legality of earlier acts of the BOU prior to the defendants becoming involved. And your lordship see in the judgment of Mr. Richard Salter QC at tab, in the supplemental bundle at tab 6. Page 49 of the bundle. Can I ask your lordships maybe just quickly to read paragraph 10, so your lordship sees what the basis of the objection was. As Mr. Salter setting out, the judge setting out the sequence, and paragraph 12. Paragraph 14, first sentence. Or you could glance through the rest of that paragraph. paragraph 15, first sentence. Accordingly, it seemed to me that it might be the right course to adjourn the amendment application for a short time to allow Ms Brown QC to revise her proposed amendments to meet these criticisms. Paragraph 18, Mrs Justice Cockrell had directed that the amendment application should be dealt with prior to the hearing of the jurisdiction applications, and so for that reason, paragraph 19, he agreed to interpose a further hearing in order to deal with it. He then addresses the objections at the bottom of page 51. The first objection was in relation to the pleading of conspiracy, and then if you would go to paragraph 44 on page 55, recording Mr Kaplan's submissions. His second and related response was to submit that these were not attacks upon the form of the pleading but upon its substance. The corrupt scheme to which the defendants are alleged to have been parties is clearly defined in paragraph 8c, which I have quoted earlier in this judgment, as a conspiracy whose aim was to take control of a Ugandan bank and sell it, or in the event its assets and liabilities for corrupt purposes. And then on bundle page 60, paragraph 74, considering the objections in turn. As to the first of them, it is easy to see why the claimants wish to allege that there was a continuum running from the, it seems, well-established wrongdoing of the Bank of Uganda with regard to the Chinese conglomerate to what they allege against the defendants. It is also very easy to see why the defendants wish to separate their actions from that earlier wrongdoing. The question which I have to decide is whether at this very early stage the suggestion that there was a single corrupt scheme, albeit one which morphed somewhat when the Chinese conglomerate dropped out, is so implausible that it has no real prospect of succeeding at trial. And then can I ask your lordships to read the whole of paragraph 76? This is referring to objections advanced by Mr Howe for D9 and D12 to 15. Your lordships get 3 points from this. First, it is the claimants who characterise the acts of the BOU from inception of the corrupt scheme to its culmination and conclusion in making the P&A agreement as one continuum, and all acts of the same nature, indivisible, indistinguishable in that sense, all part of the same. Secondly, they obtained permission to amend on that basis and used that characterisation to meet the objections of D6 to D15 to the legal viability of the unlawful means conspiracy claim against all defendants. They used it successfully. And third, they did so, and they made the amendments to bring the amended particulars of claim into the form they wanted to be for the hearing of D1 to D5's jurisdiction challenges based on Act of State a couple of weeks later. That was then the pleading before His Honour Judge Pelling. And in our submission, any question of characterisation of what is alleged in the pleading must be consistent. The identification of what issues would have to be determined must be consistent between the two in circumstances where they obtain permission to amend on that basis. Lords, that is in contrast, and I won't go back to it, with the facts in relation to Kuwait Airways and the other authorities. In our submission, the judge's conclusion on this issue in relation to Sovereign Act was correct. As my Lord Justice Phillips suggested to my learned friend's criticisms of the judge's reasoning in paragraph 30 were somewhat unfair when all that the judge was doing in that paragraph, and correctly so, was taking the claimant's own pleaded description of the P&A agreement and assessing whether that was sovereign in the light of the pleadings as a whole, which was the issue he had to consider. On the claimant's pleaded case, which remains before you exactly as it was before the learned judge, in our submission, that finding cannot be said to erroneous, and there is nothing in this ground of appeal. Lord, may I make a start, unless you also have any further questions arising out of this ground too, can I make a start on Kirkpatrick? Lords, here the appellants are explicit that they only say that the judge erred in failing to find that the Kirkpatrick limit applied to one subparagraph, paragraph 69M of the particulars. And the argument is that the English law limit on act of state based on Kirkpatrick, that the act of state bar does not apply if the court would not actually have to determine the legality of the act of state relied on. If all that is relied on is the fact of the act, then they say that is the case in relation to paragraph 69M, and that one paragraph falls outside of the act of state doctrine. Lord, three answers to that. First of all, echoing what I've said already in relation to ground two, the claimant did not advance an alternative case to the judge that if it failed on its other arguments, it applied to amend its claim so as to delete everything except an unlawful means conspiracy claim based on and only on what was alleged in paragraph 69M. So there was therefore no alternative issue for the judge to decide. Secondly, the claimant's case would not have been legally viable even if it had been amended down to that single allegation. And the claimant recognised this by, as I've shown you, by insisting to the judge determining the amendment application that it had to and did maintain its case in full width. Again, on this aspect, the appellants, it's not open to the appellants to ask the court to decide a different issue on a hypothetically pleaded basis. And thirdly, the Kirkpatrick limitation would not, in any event, even arguably apply to the allegation in paragraph 69M. So the point is a bad one, even if it had arisen for decision. My Lords, can I start with the well, let me first identify. There were two. Malone Friend's argument had two main planks. First, he said that subparagraph 69M falls within the Kirkpatrick exception, even if the rest of paragraph 69 does not. Secondly, he said that the Kirkpatrick exception applies unless the claim would require the English court to determine the validity of the act of state under foreign law. He says that it is not sufficient to engage the act of state doctrine if the claim would require the English court to determine that the acts of state in question were unlawful. That is, even if unlawful conduct of the state is a foundational element of the cause of action. Logically, those 2 points should be addressed the other way around. First, we should establish what the scope of the English principle is on the basis of Kirkpatrick. Secondly, then apply that to paragraph 69M. So let me deal on the law with the submission that the English Act of State rule only applies to require an English court to abstain from deciding validity, which in our submission is wrong, and clearly so. The starting point is UCOS, Authorities Bundle 3, tab 19. Bundle page, electronic bundle page 893. UCOS were arguing that the Act of State doctrine did not apply to its case because of Kirkpatrick, making essentially exactly the same argument as the appellants make on this appeal. If you go to bundle page 932, paragraph under the heading the Kirkpatrick exception, paragraph 95. Yet another exception, however, has been relied upon and is one of the cornerstones of UCOS Capital's opposition to this appeal. Thus it is submitted by Mr. Pollock that the Act of State doctrine does not apply in cases where there is no sitting in judgment on the Act of State alleged, but only a question or acknowledgement of whether certain facts have occurred. For these purposes, he submits that it does not matter that the finding or acknowledgement of such facts involves some inherent impropriety, provided that there needs to be no investigation into the validity, lawfulness, or motives of the state's acts. Lord Justice Ricks then reviews the English cases which he considered Kirkpatrick and doesn't think that he gets much assistance from them. And then at paragraph 104, bundle page 935, he says, in our judgment, whatever might otherwise be the width or narrowness of the Act of State doctrines, we cannot agree that these four authorities or any others support treating the allegations in this case as simply being concerned with proving what occurred and not with castigating what occurred as wrongful, and therefore to be regarded as ineffective. Moreover, inasmuch as UCOS Capital submits, as it does, that it is no part of UCOS Capital's case that any act of state was illegal or wrongful, all that, and he then quotes from their submissions. He then says that underneath the quote, those submissions are not understood. It seems to us to fly in the face of UCOS Capital's pleading. That pleads that Russian law was deliberately misapplied as a matter of state policy, and inter alia on that ground, the English court is asked to find that the tax assessments and decisions and the annulment decisions are to be regarded as ineffective and invalid. Then he deals with challenge to validity, paragraph 105. We come finally, therefore, to UCOS Capital's most fundamental formulation as to the narrow limits of the Act of State doctrines, and that is that they are engaged only where there is a challenge to the validity of an Act of State or where the English court is requested to grant a remedy in respect of such acts. And Lord Justice Ricks then considers that, points out that that issue, paragraph 107, that issue had been raised in the Berezovsky case, paragraph 107. So ultimately, that issue raised in the Berezovsky case, which can perhaps be expressed as to whether it makes a critical difference to reliance on the Act of State doctrine, whether the challenges to the Act's validity or its general wrongfulness was left unresolved. I think my Lord Justice Popplewell may have made submissions on that issue in Berezovsky. And then at the top of the next page, para 109, and again, my lords, for speed and transcribers' fingers at the end of the day, can I ask your lordships to read paras 109 and 110? Thank you, my lords. And then the Kirkpatrick was then next considered in Belhadge by Lord Sumption. Just one, two sentences to show your lordships before then finally Maduro. So this is Authority Bundle 4, tab 22, bundle page 1252. Under the heading incidental unlawfulness. Bundle page 1252, paragraph 240. The Act of State doctrine does not apply in either form simply by reason of the fact that the subject matter may incidentally disclose that a state has acted unlawfully. It applies only where the invalidity or unlawfulness of the state's sovereign acts is part of the very subject matter of the action, in the sense that the issue cannot be resolved without determining it. And then he applies that to the claim in Belhadge at paragraph 242 on the next page. In the present cases, the question whether the acts alleged against the relevant foreign states were unlawful is not incidental. It is essential to the pleaded causes of action against the defendants in both means. This is because the various civil wrongs which are alleged to have caused damage to the claimants are not said to have been committed directly by the defendants. They were committed by the foreign states. If the conduct of the foreign states was lawful, it cannot be tortious for the defendants to have assisted in their commission. And the Court of Appeal analysed it in that way, and I think that their analysis is unanswerable. And we would say exactly the same goes for the claimant's claim in this case, as is evident by the fact that the unlawful means relied on as the basis for unlawful means conspiracy, and the breaches and unlawful acts which are said to have been dishonestly assisted are acts of the BOU. And then finally, Maduro, bundle 7, tab 34. Bundle page 1981. Paragraph 136 of Lord Jones's judgment. Sub 5, which we've looked at, or my friend took you to. The important point to note there is the reference to UCOS and the approval of that, including therefore the Lord Justice Ricks's determination that the rejection of the argument that it only applied where validity was put in question, and indeed that's also apparent from Lord Jones's formulation, where the court is asked to inquire, does not apply where the only issue is whether certain acts have occurred, as opposed to where the court is asked to inquire into them for the purpose of adjudicating on their legal effectiveness.
A convenient moment.
Lord, yes, sorry I've gone a little past, but that
It seems sensible to let you finish that. We're in no danger of not finishing in good time tomorrow.
definitely in no danger of finishing within,
10:30
not finishing within tomorrow.
Does your lordship mean by 4:15 tomorrow?
by the end of the day.
Yes, yes.
But we'd quite like you to finish by lunchtime or thereabouts, but if you can't, you can't.
Indeed,
How long you
I
think
shall
you're
be
going to be?
brief, I hope, in reply. It's really a matter for my friends how much
We've got
longer
one more
they need.
topic to cover, or two more topics to cover. I
I've
suppose.
got public policy
and
and Article 6. Lord, I won't finish. I won't finish before lunch, but if I go past lunch, I don't think I will go very far past.
No one.
All rise.